To prevent overzealous prosecutions, the Fifth Amendment requires a grand jury indictment before a person can be prosecuted for a capital or infamous crime. But if the grand jury indicts, must the prosecutor prosecute? In United States v. Cox, the Fifth Circuit faced this question. Goff and Kendrick, both African American, testified in a voting rights case brought by the United States against Ramsey, a Mississippi County registrar, and the state of Mississippi. Goff and Kendrick testified that Ramsey had refused to register them to vote, while at the same time registering whites. Ramsey testified that he'd never discriminated against blacks. The presiding judge, W. Harold Cox, said that Goff and Kendrick should be prosecuted for perjury. Upon the request of the Department of Justice, or DOJ, the Federal Bureau of Investigation, or FBI, investigated the potential perjury. After a full investigation, the DOJ informed the local United States attorney, Hauberg, that there was no basis for a perjury charge. Acting Attorney General Nicholas Katzenbach explained the DOJ's rationale to Judge Cox, but Cox remained adamant that the case should be presented to a grand jury. Thereafter, Kendrick and Goff were arrested and indicted by a state grand jury for testifying falsely in federal court. The DOJ successfully sued the state district attorney to enjoin the prosecution. Undeterred, Cox arranged for testimony before a federal grand jury about the alleged perjury. Katzenbach instructed Hauberg not to prepare or sign indictments. When the grand jury told Cox that Hauberg had refused to prepare perjury indictments for Goff and Kendrick, the judge ordered Hauberg to disregard Katzenbach's instructions and to draw up and sign the indictments. After Hauberg again refused, Cox found him guilty of contempt. Hauberg and the federal government appealed to the Fifth Circuit.